My name is Tom Justice and I'm an associate solicitor in the commercial team at Muckle, and today I'm going to be talking about getting your contracts right. Drafting and negotiating contracts can be intimidating because there's an awful lot of information to take in and a lot of legalese and expressions that maybe don't make a huge amount of sense. But negotiating contracts doesn't need to be complicated. There's really just some key things that you need to look at each time you're thinking about drafting or negotiating contracts. So your standard terms and conditions are the terms and conditions that are often attached to other pre-contract documentation like sales orders, order forms or something along those lines. But it's essentially a set of terms and conditions that don't change from customer to customer. They stay the same for each individual. On the other hand, a bespoke contract is an agreement that's literally been drafted for a specific purpose. So a business might come to us and say, we're entering into a contract with such and such for a very specific thing, whether that's sale of goods or services. We will literally draft a contract from scratch for them. It's really important to avoid ambiguity in a contract for lots of reasons. You've got to draft them thinking about third-party objectivity. So someone that you don't know, doesn't know who you're contracting with, picks up a contract and tries to read it and tries to understand what the objectives of the party are. That if you leave room for ambiguity, then if a judge picks it up, they might agree with you, but equally they might agree with the other side too. It's much better to be very, very clear, and if you need to, labour the point. It's really important for contracts to be specific about the goods and services they provide, again, in case there's a dispute later down the line. You need to be really clear about if you're receiving the goods. It'd be really obvious to you exactly what kind of goods you expect to be provided or the level of the services that you would expect to be provided. It can be helpful to include a specification within the contract itself, which sets that out in more detail. That's something that you may be able to rely on. It's also really important to be clear whether something is an absolute obligation or a qualified obligation. So, for example, if we're talking about something like delivery, it's important to make it clear whether delivery is what we call of the essence of the contract. Does it have to be delivered on a specified date, or will a party just use their reasonable endeavours to deliver the goods on that date? There's a real important difference there because it comes down to enforceability and whether there's a breach of contract. The commercial reality, we'd all love to think that once we're done negotiating a contract, we can just stick it in a drawer and never think about it again. But the reality is things change. So you need to try and cover that off as best as you can when you're entering into a contract. So think about the things that might impact on the goods that you're receiving or the services that you're supplying. So how would we deal with delays? What if the cost of raw materials increases? We need to include an objective criteria that can easily be followed by the parties if one of those situations occurs. And again, you've got to think about third-party objectivity. So could a third party pick this contract up and show you how to go through a price review, for example? Like any other provision, termination rights need to be set out clearly from the off. Termination rights are, put simply, how you would get out of the contract. It doesn't necessarily have to be if something's gone wrong. It can be without cause. So it may just be a termination right on 3 months' notice, and you don't have to give a reason why. But there should also be termination rights if something goes wrong. So if there's a material breach of the contract, or if the other party goes insolvent, for example, then there needs to be clear provisions in terms of how the contract can be terminated in those circumstances. Thanks very much for watching. We hope you found this useful, and if there's anything else we can do to help you get your contracts right, please don't hesitate to get in touch.